Here's a number that gets everyone's attention immediately. Penalties under DPDP can reach up to 250 crore rupees for a single violation, and unlike some frameworks with flat penalty caps, the actual amount scales based on the nature, severity, and repetition of the violation itself. Let's frame this chapter properly before diving into specifics. Everything we've studied so far, definitions, obligations, rights, the board structure, exists to enable one final outcome: genuine consequences when violations occur. Without meaningful enforcement, even the most well-designed law becomes just words on paper. I remember a client's CFO asking a genuinely blunt question early in a compliance project: what actually happens if we just don't bother complying? That question, however uncomfortable, deserves a direct answer, and this chapter provides it: real financial penalties, appeal mechanisms, and structured dispute resolution pathways. Think of it like traffic enforcement. Speed limits alone don't change driver behavior; cameras, fines, and license consequences do. DPDP's penalty and appeals framework is exactly that enforcement layer, transforming legal text into genuine behavioral incentive for organizations handling personal data. We'll move through appeals first, understanding how organizations can challenge board decisions they believe are wrong, then into the penalty schedule itself, and finally the miscellaneous provisions that, despite sounding administrative, often matter enormously in practice. Let's begin with what happens when someone disagrees with a board ruling. No enforcement system should operate as the final word without any recourse, and DPDP recognizes that through appeals to the Appellate Tribunal, specifically the Telecom Disputes Settlement and Appellate Tribunal, or TDSAT, which handles DPDP appeals alongside its existing telecom jurisdiction. Think about why this matters for genuine fairness. Imagine an organization receiving what it genuinely believes is an incorrect or disproportionate board ruling, perhaps based on a factual misunderstanding of their technical systems. Without an appeal mechanism, that organization would have no recourse beyond the board's own decision, however flawed. I worked with a client who initially assumed a board decision was completely final and unchallengeable, and that assumption shaped their entire response strategy towards simply accepting an outcome they genuinely believed was factually wrong. Once we clarified the appeal pathway existed, their approach shifted considerably, from resignation to structured, evidence-based challenge. Here's an interesting design choice worth noting: why TDSAT specifically, rather than creating an entirely new appellate body? Think about it practically. TDSAT already possesses deep expertise handling complex technical and regulatory disputes in the telecom sector, expertise that transfers reasonably well to data protection matters involving similar technical complexity. So here's what this means for your work going forward. A board decision genuinely isn't the end of the road if your organization has legitimate grounds for challenge. Understanding this appeal pathway exists should inform how you approach any adverse board ruling, not as an automatic final defeat, but as one stage in a structured legal process. Not every disagreement needs to escalate through formal adjudication, and DPDP explicitly recognizes this through provisions encouraging alternate dispute resolution, mediation, and similar mechanisms before or instead of full board proceedings in appropriate circumstances. Think about why this option genuinely matters practically. Formal proceedings, even streamlined ones, consume real time and resources for everyone involved: complainants, organizations, and the board itself. For disputes where genuine resolution is possible without extensive investigation, mediation offers a faster, less adversarial path forward. I recall a scenario involving a mid-sized retail client facing a customer complaint about excessive marketing communications despite opt-out requests. Rather than escalating to full board proceedings, both parties agreed to mediated resolution. The company fixed their opt-out system promptly, offered a genuine apology, and the customer withdrew their complaint. Weeks resolved in days. Here's an analogy worth considering. Think of alternate dispute resolution like a workplace mediator resolving a conflict between colleagues rather than immediately escalating every disagreement to formal HR proceedings or legal action. Sometimes direct, structured conversation resolves things faster and more constructively than heavier institutional machinery. So here's a practical mindset worth adopting. When facing a genuine, resolvable privacy grievance, consider whether mediated resolution might serve both parties better than immediately bracing for formal board proceedings. That approach often preserves customer relationships far better than purely adversarial engagement. Here's a provision that rewards proactive accountability: the voluntary undertaking. An organization facing a potential violation can voluntarily commit to specific corrective actions, potentially avoiding or reducing formal penalty proceedings, provided the board accepts that undertaking as genuinely adequate. Think about the psychology this provision encourages. Imagine an organization discovering an internal compliance gap themselves before any complaint or investigation begins. Under this provision, proactively approaching the board with a genuine remediation plan can be treated very differently than waiting to get caught and investigated. I worked with a client who discovered through their own internal audit that a legacy system had been retaining data well beyond its lawful purpose, a clear Section 8 violation. Rather than hoping nobody noticed, we helped them prepare a voluntary undertaking, complete remediation timeline, system fixes, and process improvements submitted proactively to the board. Here's an analogy that clarifies this well. Think of it like voluntarily disclosing a tax error to authorities before an audit catches it versus getting caught during enforcement action. Most regulatory frameworks, and DPDP is no exception, treat proactive disclosure and genuine remediation far more favorably than reactive, forced compliance after detection. So here's a strategic question worth asking regularly within your own organization. If an internal audit revealed a genuine compliance gap today, would your instinct be proactive disclosure and remediation, or hoping it goes unnoticed? This provision exists specifically to reward the former instinct. Let's walk through how the board actually reaches a final decision once an inquiry concludes the adjudication process. This involves reviewing evidence gathered during inquiry, hearing both parties, and issuing a reasoned decision, which may include penalties, corrective directions, or both, depending on findings. Think about why reasoned decision matters so specifically. Imagine receiving a significant penalty with no clear explanation of which specific provisions were violated or why. That opacity would make genuine future compliance nearly impossible. Organizations need clear guidance on exactly what went wrong to actually fix it. I reviewed an adjudication outcome once with a client, and what struck them most wasn't the penalty amount itself, but how specifically the decision identified failures, inadequate breach notification timing, insufficient security safeguards for a particular data category. That specificity became genuinely useful for their remediation planning going forward. Here's an analogy worth considering. Think of this like a detailed medical diagnosis versus simply being told something's wrong. A reasoned adjudication decision functions like that detailed diagnosis, identifying precisely what failed, enabling genuinely targeted correction rather than guesswork. So here's why this process design matters for your broader understanding. Adjudication isn't purely punitive, it's also genuinely instructive, both for the organization involved and for the broader industry watching how the board interprets specific provisions in real concrete circumstances. Now let's address what everyone ultimately wants to understand clearly: the actual penalty amounts. DPDP's penalty schedule scales significantly based on violation type. Failure to implement reasonable security safeguards can attract penalties up to 250 crore rupees, while certain other violations carry different, sometimes lower, specified caps. Think about why penalties vary this significantly across violation types. A security failure leading to a massive data breach affecting millions of individuals represents fundamentally different risk than, say, a minor procedural notice deficiency affecting a small user base. The penalty structure reflects that proportionality deliberately. I remember a client's leadership team initially fixating entirely on the headline 250 crore figure, treating it as the automatic penalty for any violation whatsoever. That's simply not how it works. The board considers factors like severity, duration, whether the violation was repetitive, and the nature of harm caused before determining an actual penalty amount within applicable caps. Here's an analogy worth considering. Think of this like traffic violation penalties. Running a red light carries meaningfully different consequences than reckless driving causing serious injury, even though both technically violate traffic law. Proportionality between violation severity and consequence is the underlying design principle here too. So here's the practical mindset worth adopting regarding penalties. Don't fixate purely on the maximum headline number, understand which specific provisions carry which penalty exposure, and focus genuine compliance energy on the highest risk gaps within your own organization's actual data processing activities. Here's something worth understanding clearly. The Act itself is deliberately not the complete picture. Section provisions grant the central government power to make detailed rules filling in operational specifics, exactly what we saw happen when the DPDP rules were finally notified in late 2025. Think about why this layered structure makes sense. Imagine trying to specify every technical detail, exact breach notification formats, specific security standard benchmarks, precise consent interface requirements, directly within the Act itself. That would make the law simultaneously rigid and instantly outdated the moment technology evolved. I remember discussing this with a client's technology team who initially treated the Act's passage in 2023 as the complete compliance picture. When the rules finally arrived in 2025, adding substantial operational detail, their reaction was somewhere between surprise and mild panic, realizing genuine implementation specifics had been waiting in this rulemaking layer all along. Here's an analogy worth considering. Think of the Act like a building's structural blueprint: walls, load-bearing points, overall design. The rules are more like detailed interior specifications, exact electrical wiring standards, plumbing codes, finishing materials. Both matter enormously for actually inhabiting the building safely. So, here's a practical habit worth building going forward. Never treat primary legislation alone as your complete compliance picture. Always actively track subordinate rules and government notifications, because that's frequently where genuinely actionable operational detail actually lives. Here's a procedural safeguard that might sound purely technical but carries genuine democratic weight. Rules made by the central government must be laid before Parliament, allowing for parliamentary scrutiny and potential modification before becoming fully binding. Think about why this matters beyond administrative formality. Without this requirement, the executive branch could effectively rewrite significant operational aspects of the law through rules alone, without any legislative oversight or accountability. That would concentrate enormous unchecked power in rulemaking authority. I discussed this once with a client's legal counsel who asked, reasonably, can the government just change the rules whenever they want, without any check? The honest answer involves this exact provision. Parliament retains oversight capacity, even though day-to-day rulemaking authority sits with the executive branch. Here's an analogy worth considering. Think of this like a company's board of directors delegating certain operational decisions to management, but still requiring those decisions be reported back for board review and potential override if genuinely problematic. Delegation exists, but ultimate accountability remains anchored at a higher level. So while this provision rarely makes headlines the way penalty amounts do, it represents an important structural safeguard, ensuring the rules genuinely reflect legislative intent over time, rather than drifting unchecked through purely executive discretion. Every new law inevitably encounters unforeseen practical complications during implementation, and this provision addresses exactly that reality, granting the central government limited power to issue orders, removing genuine difficulties encountered while bringing the Act's provisions into effect. Think about why this flexibility matters practically. Imagine a genuinely unforeseen technical or procedural conflict emerging during early implementation, something the original drafters simply couldn't have anticipated. Without this provision, resolving that conflict might require the far slower, more cumbersome process of formal legislative amendment. I recall discussing this with a client during the early implementation period, when several practical ambiguities around specific compliance timelines created genuine confusion across industry. This provision exists precisely to allow relatively swift administrative correction for exactly these kinds of unforeseen implementation gaps. Here's an analogy worth considering. Think of this like a building's occupancy certificate process, allowing minor practical adjustments discovered only once people actually start using the space, without requiring the entire structural blueprint to be redrawn and reapproved from scratch. Here's an important limitation worth remembering, though. This power is deliberately narrow and time-bound, designed for genuine implementation difficulties, not as an open-ended tool for substantially rewriting the Act's actual policy intent through administrative shortcuts. DPDP didn't emerge in complete isolation. It required corresponding amendments to existing laws, most notably the Right to Information Act, to ensure consistency across India's broader legal framework rather than creating conflicting obligations. Here's where this gets genuinely interesting and occasionally controversial. The RTI Act previously allowed disclosure of personal information in certain public interest circumstances. DPDP's amendments narrowed some of that disclosure scope, creating real tension between transparency advocates and privacy protection goals. I discussed this specific tension with a journalism-adjacent client concerned about investigative reporting access to certain public records. This genuinely represents one of the more debated aspects of DPDP's broader legal impact. Privacy protection sometimes creates friction with other legitimate values like government transparency and accountability. Think of this like renovating one room in a house and discovering it affects plumbing connections throughout the entire building. DPDP's privacy protections, however well-intentioned, ripple outward into other legal frameworks built on different underlying assumptions and priorities. So here's why this matters beyond abstract legal interest. If your work touches areas where transparency and privacy genuinely intersect, government contracts, public records requests, journalism, Understanding this amended RTI relationship helps you navigate what's now a more privacy-protective information disclosure landscape than existed previously. Finally, let's address two related provisions that shape how disputes actually get resolved procedurally: bar of jurisdiction, which limits civil courts from hearing matters specifically assigned to the board, and protection of action, which shields board members and officers from personal liability for actions taken genuinely in good faith while performing their official duties. Think about why jurisdiction limitation matters practically. Without it, organizations facing board proceedings might attempt parallel civil court litigation simultaneously, creating genuinely conflicting outcomes and significant procedural chaos. Channeling DPDP disputes specifically through the board maintains consistency and genuine specialized expertise in decision-making. I worked with a client whose initial legal strategy involved exploring civil court options alongside board proceedings, essentially hedging across multiple pathways simultaneously. Understanding this jurisdictional bar clarified that the board represents the primary, often exclusive pathway for these specific matters, not simply one option among several available. Think about protection of actions similarly to good faith immunity provisions protecting company directors making reasonable business decisions. Without this protection, board members might genuinely hesitate to make difficult, potentially unpopular rulings, fearing personal legal exposure for good faith professional judgment calls. So here's why these seemingly technical provisions matter enormously in practice. They ensure the board functions as a genuinely confident, decisive enforcement body, rather than a hesitant institution constantly second-guessed through parallel litigation or personally liability-anxious members reluctant to rule firmly when warranted. Let's bring Chapter 7 together. We explored the appeal pathway through TDS-AT, ensuring board decisions aren't final and unchallengeable, alongside alternate dispute resolution and voluntary undertakings that reward proactive, good-faith engagement rather than purely reactive compliance. We examined the adjudication process itself, designed to produce reasoned, instructive decisions rather than purely punitive outcomes. We then covered the actual penalty schedule, scaling significantly based on violation severity, up to 250 crore rupees for serious security failures, and the important miscellaneous provisions, rulemaking power balanced by parliamentary oversight, narrow difficulty removal authority, consequential amendments to laws like RTI, and jurisdictional and liability protections keeping the board functioning confidently and consistently. Together, these provisions transform DPDP from well-intentioned legal text into a genuinely enforceable framework with real consequences. If you want the fully structured version of this journey, complete with role-plays, scenario-based quizzes, and practice tests, check out our complete course, DPDP Act Compliance Masterclass, on Udemy, linked in the description below. Also, subscribe so you don't miss what's coming next, and click on the DPDP Act Master Series playlist in the description for the complete sequence. Next up, we shift from legal text to practical application, walking through the complete data lifecycle in action. See you there.